said, or emailed you and said, gee, would you like to come to the International Humanitarian Law Dialogue? What was your expectation?
Well, I knew about some of the prior dialogues because obviously I have friends who are prosecutors who I had met and heard them talk about it. Dave Tolbert was one who's become a good friend, and of course Kelly and various other people. So I thought it was great. I was delighted to be invited. And that was even before I knew what the theme was going to be.
Right.
So when I found out that the theme was going to be the role of women, then I was doubly grateful. Now, the one thing I have to tell you, and maybe you won't pass it on to David, is one of us is mistaken about the communications, because I thought right up until, I would say, 2 weeks before I came here, that I was just coming.
I didn't know you'd putting you to work.
I did not know that he had scheduled me for a keynote address. And then I got a copy of the invitation which said keynote address. So I emailed him back and I said, you know, is this for real, David? He said it was. I was pleased to do it. It was summertime. I had a little bit of time. But I was just glad that I didn't get up here thinking that I was going to be able to sit and partake of everybody else's wisdom and suddenly find myself called upon. So.
No, well, it was just terrific what you did and how you said it. You were sort of a first, talk about women, you were first along the way in many instances.
In some, yes. That's attributable to, you know, the coming together of events, and the timing. I mean, I went to law school in the 40s, in the late 40s, right after World War II, 48 to 51. And, you know, it was interesting. It was more women than you would expect at Yale Law School, because the law school during the war didn't have as many young men, you know, who they would normally admit they were being drafted, etc. So they let in a much greater number of women than they would normally. And so some of them, the war ended, and so they were kind of stuck with the women that they had let in. So we ended up having a class of about 10. But yes, I happened to be around again in the 60s when women were first being called upon, not called upon, were given some greater opportunity than they had had in the past to enter even the government. But when I first got out of law school, it was tight. It was tight for women. The only place that had any reputation for taking women in Washington was the National Labor Relations Board.
Why was that?
Well, women just didn't get hired. There were virtually none in the law firms. I did get hired by a law firm, but that was due primarily to the fact that I had some lucky breaks. I had clerked for a federal circuit judge, Jerry Frank, in the Second Circuit, who was the only judge who took women law clerks. He didn't take one every year, but he had one or two others in other years besides me. Judges only had one law clerk at the time. And he was a good friend of these ex-New Deal people who had gone to Washington. He had been, chairman of 2 New Deal agencies himself. And so he knew people like Thurman Arnold and Abe Fortas and Paul Porter and Frank Shea. He actually gave Frank Shea of the Nuremberg, Frank Shea's.
Sure, absolutely.
He gave me, a really good recommendation, so I at least could get in the front door. And so he gave me a recommendation of Frank Shea's, Shea and Gardner, which he formed, and one to Arnold, Fortas, and Porter, where they did make me an offer. So that was how I got my foot. But there were, I didn't know more than a couple other women who were in law firms down there. And the women who were in my class who came to Washington, virtually all of them, just the ones that went into the government, went into the NLRB, had a reputation as taking women. But I can't think of, there were none that I knew of that went into the Justice Department, et cetera, at the time.
You mentioned Judge Frank. He's an icon. What was he like?
He was a wonderful man. He was, somebody once said, that he would, in the course of an hour, he would probably have a dozen new ideas about which he was enthusiastic and ready to go. And about 10 of them would not work out, but the other 2 would be great. So that's not a bad percentage. And he saw some of the real problems in the criminal justice area, particularly way ahead. He was writing about poverty and talking in his opinions about poverty and its effect on its unfair effect upon the criminal justice system. He was talking about the right to counsel. This was long before Gideon versus Wainwright. He was thinking about terms of equality. Obviously, he cared the fact he was hiring women at all. He cared about that aspect of it. But he was a little bit eccentric. But I had a marvelous year with him, and I wouldn't have given it up for anything. And again, it was that clerkship which stood me in good stead when I looked for other jobs.
That was district court, and then
No, that was circuit court.
circuit. Okay.
Yeah, I clicked on the circuit court. He was a circuit court judge.
That's right.
But I don't know if he. I would guess he must have known Jackson. I mean, having served in the New Deal so long, and considering Jackson's prominence.
When you were at Yale, did you study Jackson? Was that a known commodity at all?
Well, I tell you, my memory, it's been a long time ago, is that we knew, obviously as law students, we knew who was on the Supreme Court at the time. So I certainly knew who Justice Jackson was, but we didn't ever study them.
Right.
And we would study particular decisions.
Right.
And I remember being familiar with some of the the outstanding decisions, things like Kawamatsu, and Youngstown came a little bit later. And as I was chatting with you before, my memory, I won't say is 100% correct on this, but as I pointed out, this one decision, which is not among his most well-known decisions, I'm pretty sure he dissented in a case called Metzi versus whoever the head of the immigration decision was then, or else it was something like In Re Metzi or Ex Rel Metzi, one of those, about the person trying to come in the United States who was turned back for not terribly significant reasons. And the country wouldn't take him back, and so he was sort of going between here and there, like the Flying Dutchman. The district court, Irving Kaufman, who my husband clerked for, granted a right of habeas corpus and said if you can't find some place for him to go, you can't keep him there indefinitely, you have to release him on conditions or whatever it was. He was not a dangerous person by any means. It was kind of a technicality that he couldn't meet the qualifications for coming in. And it went up to the circuit, which said, oh no, the immigration department has the power to do this, and went up to the Supreme Court. My memory is that the Supreme Court upheld the right not to release him on habeas corpus, but I think Jackson dissented on that, though that's one of those things that would have to be checked out. So, and I certainly remember the Barnett, the flag salute case. Now, what's interesting about that is we were, of course, this would be a few years after Nuremberg. I went in 48. We didn't really have in law school, I don't remember there being a great deal of emphasis on Nuremberg. I knew it was there, and we had a small coterie of students, I think probably all male at that point, who were interested in international affairs, some of whom, later took prominent parts. Dick Gardner was in our class, and he later became the ambassador to both Italy and Turkey. But then the women were more practical-minded. I mean, I guess we were all worried about where we were going to get jobs. And so I didn't take any international courses, although I certainly regret it in retrospect because Ralph Lemkin taught a course at
Really?
Yale at the time on genocide, and I remember hearing people talking about it. And McDougall and Lasswell were teaching courses. I had McDougall, but not for international law, for just the general property course. So I, had no inkling of how important those it would have been if I had studied those courses there. But I certainly knew Justice Jackson was there. I had an impression on him. I never did actually meet him. Well, I guess that's it.
When you were in the court with Judge Frank, it would have been 51 and 52?
Yes.
So the Youngstown Steel seizure would have been decided that term period. Do you remember Judge Frank commenting at all on that?
No, I don't.
Yeah.
I don't remember his commenting on it. I do remember how it became, that decision, had its effect at later stages in my own career, because I served on the D.C. Crime Commission in the 60s with Judge Pine. And Judge Pine had written the district court decision in Youngstown, for which he was, he decided in the right way, in the right way by our case, but in the same way. Yes. Although in other respects, Judge Pine was very conservative, Republican, I think it was Republican, but anyway, very conservative judge on criminal cases, and somebody with whom I had lots of differences on the Crime Commission about, the extent to which the government could take actions against individuals in criminal situations. But Youngstown, I don't need to tell you, and I was just glancing through this book, but Youngstown is constantly being cited. When I went into the Carter Justice Department, I was in charge of legislative affairs, and that was the year in which we passed the very first Foreign Intelligence Surveillance Act. And the big debate inside justice, as well as in recent years, about all the various amendments or the various non-observance of it that we know about in the wiretap surveillances. Always Jackson's concurrence was, we always drew out and said no. The issue was raised about whether the president had inherent power over and above the Foreign Surveillance Act, whether or not he had reserved some area of power under commander-in-chief powers that transcended all the restrictions that were put on. And we argued, and I remember, in my memory, Attorney General Bell, whom I served under, accepted the fact that no, if Congress passed the Surveillance Act, that was, Congress had entered that field, and there wasn't any, in a very decisive way, there wasn't any power left behind for the government. On the other hand, the Bush administration was arguing, yes, there was some component of power that was left behind. So this became certainly something that was constantly rising up. Now, Korematsu, of course, was another case that we all admired, respected. Justice Jackson's dissent there. A good friend of ours is Neil Rutledge, he was my husband's roommate at Harvard. And Neil, his father, of course, was on there. And Neil always said that his father, always, that was one of his lasting regrets, Justice Rutledge, that he had gone along with that. And of course, Justice Jackson did not. I had the opportunity to meet Fred Korematsu and several times, because when the whole problem came up again in Guantanamo, detainees and all of that, and after I left the court, I've been associated with a lot of NGOs, civil rights NGOs, so I had the chance to meet Korematsu on that. So he seemed, Justice Jackson seems to me from afar, as I say, I never had the opportunity to meet him, to have kind of, not saying I agree with every decision he wrote, but he had a special talent to pick the most important cases, and that he would dissent on sometimes when the people you would have expected, the liberal people more, the liberal justices more on the other side of things, did not. I also always admired him because I don't know when I found out, that he had not had a traditional education. He was not a product of the Eastern Seaboard, and because I came from working class folk, I was the first person in my family that ever went to college, let alone law school. And I worked in the factories in the summertime and went to school on scholarships all the way through. So that was always a kind of nice thing to think that somebody could go all the way there. Now, the one other very small point was that when I left the court, the D.C. Circuit, after I'd been there for 20 years, and I had the opportunity to go over to the ICTY to fulfill the end of Gabby McDonald's term. She had been the first American judge. I was already at the point where I could have taken senior status, at the court. I was the age, the so-called rule of 80, 10 years plus your age had to add up to 80. But I would have liked to have taken a leave of absence and done it. So the same old question came up. Could you take a leave of absence? And what had happened in the meantime, certainly everybody knew about the precedent of Jackson, but in the meantime, the Federal Judicial Code of Conduct, which is interpreted by the Judicial Conference, had come to the opposite conclusion, that you could not leave the federal judiciary. You could leave it, but it had to be a complete retirement. I couldn't go away and come back. So I had to make a more basic decision about whether to leave the D.C. Circuit. I was really sorry that Justice Jackson's precedent did not prevail. But actually, they had decided about 15 years earlier with a colleague who was on the court when I first came in, Malcolm Wilkie, had been appointed by first President Bush he wanted to appoint him to chair the Iranian Claims Commission, which was in the early to mid-'80s or somewhere around there. And Malcolm wanted to take a leave of absence, go over and do that, because he was eligible too by that time for senior status, and went all the way up to I think Chief Justice Berger there. They said no, he couldn't. So he just left, and he didn't do that. He stayed on. He had another year or so before he was eligible for senior status. So he stayed on, and then he left at the point he was eligible and went on and became ambassador to Uruguay and some other things. But that was the precedent they used on me instead of Jackson. So that's where the law is today. I think it's a very short-sighted policy. As we heard at this dialogue, the excellent woman from Kosovo was allowed to take a leave of absence from her court. I know several other state judges who are allowed to. You would think the government would want to encourage, especially if you're at the point where you could walk away anyway, and you would want to encourage people to contribute their services, but they're in sort of a blind spot.
You obviously made that decision to become a judge, and what drew you to something? This is a brand new, virtually new tribunal, first tribunal since really Nuremberg. The ICTY is. Well,
I'll tell you, I had in my extracurricular activity while on the court, and federal judges, you're pretty limited in what you can do, in terms. But I had been very active with the American Bar Association's Sealy project. So I had visited all these countries in the Eastern Europe, worked on drafting constitutions, laws, judicial training. That included some of the Balkan countries. In other words, I'd been over to Bosnia I think it was 96 I was there. I was over to Belgrade in 98. And so I did have some sense of the, what was going on after the Dayton Accords, and that sort of, I kept track of because I just was interested and fascinated by it. I kept track, but just from a citizen's point of view, I knew Conrad Harper, who was the State Department, a counselor, and later on David Andrews. So who were the persons who were in charge of initiating nominations in this process in the State Department? And somebody asked me in 92 if I was interested. But that would have been before I was eligible for senior status. If I had been interested then, I would have had to give up basically my pension, my judicial pension, which after that long number of years, it was not, we have 5 children and et cetera. Neither one of us has been a giant moneymaker, and that just did not seem in the cards. So I kept sort of track of it, and then when the opportunity came along and I could now leave and keep my pension. It was one of those things I knew I wanted to do it. There's some decisions in life that you have to think hard and worry, and so there's just some you think, well, there will be obstacles, but by God, I want to do this. Right. And this fell into that particular category.
Did your husband go with you?
No, he had his own law firm. Well, by that time, that had merged with some others. But no, he had an active practice at the time. He wasn't going to drop everything. But he was wonderful. He would come over. I mean, I lived there the whole time. He would come over on the average of once a month and stay for several days or a week. He once said he figured out in the couple of years I was over there, he made 33 trips to The Hague and back again. And actually, it turned out to be, fun for me and for him, because on the weekends we would take off to some other part of. Sure. Go take a weekend in Spain, a weekend in Portugal, something ordinarily we wouldn't. So, it's always a personal break if you, you leave your moorings. But we had able to maintain sufficient contact by phone. He came over. My kids are all grown and off living their own lives too. So I never felt any, that was any great sacrifice.
During that two-year period?
Yeah.
And you finished out a term. Is that what it was?
Yes, yeah. That's exactly right.
Were you interested in an upgrade?
Well, several things happened that didn't quite fall into place. One, I did have the sense that it was, at the end of the 2 years, that it was taking a lot out of my husband, who he has something called neuropathy in his feet and legs, and it was taking a lot out of him. But then there were 2 other things. One, it was the end of the term, of the presidential term. And so, as it turned out, President Clinton nominated, or could nominate somebody before, or he tried to nominate somebody before he went out of office. In fact, who he did nominate was David Sheffer.
Oh, yeah.
Then President Bush wins the election. He withdrew that nomination and put up Ted Maron, who was his nomination. So, there was that too, that politically, you'd never be able to predict. I don't think he would have treated me any differently than he treated David Sheffer. So, it looked like it just wasn't in the cards.
What was your assessment of your 2-year opportunity there in Yugoslavia from?
The assessment of the court?
Yeah,
or
assessment of the court, and kind of how it was progressing at the time?
Yeah, well, I hit it at a stage where it finally had a cluster of defendants in the dock. As you know, it had gotten started very slowly. And by this time, there were people waiting to be tried, so you had a regular routine. And my assessment was that there were some excellent people there, but that the judges were uneven. There were some really terrific judges there. I mean, I'll point out the judge from Australia, David Hunt, who I thought was just great. Richard May, who had his tragically died a few years later, the same year as Milosevic, in the middle of the Milosevic. I liked a great deal and thought was very, very able. And there were certainly a couple of others. Some of the judges were not judges. I mean, there was a joke that David Hunt used to say, well, we have real judges, and then we have people who are appointed to the court. Some people at that point, I think national governments, which make the initial cut, about who they'll nominate, and then the assembly, if they're elected, picks mostly on regional grounds. They balance, the Caribbean gets one, or the Western Europe gets one, or Eastern Europe. They don't really do a merit look at, as somebody at the UN said to me, unless the person comes in with two heads, we're going to go with the national selection. And some countries, I think, either didn't fully realize the importance of the court. They thought of it as maybe some place to send an old person, a diplomat or somebody, or even if they wanted to move somebody out of the government, move them someplace else. So you had some people who didn't understand what a court was. I mean, they were able people in their own field, be it diplomatic or academic, but they'd never had any role as a prosecutor, as a defense attorney, as a judge. And a criminal trial, still the essence of a criminal trial is to give somebody, the rule of law is to have somebody who understands what the whole function of it is and the rules that you have to follow. And there were people that were put in the trial court who simply did not have any conception of that. Now, fortunately, the trial bench in the courts are 3 judges, so, usually there might be 1 or 2, hopefully, that would. But still, it's very, some judges would do strange things in the courtroom. Now, I think that's gotten much better since I've left, because I think the court has itself, and the other courts too, and with the coming of the ICC, realize these international courts are important now, has come out in the last couple of days, so they're thinking harder about the people they put up. So that was one thing. The second was, it certainly was a change of pace to be in a court where the rules, are a combination of civil and common law. To get used to some of the procedures, which, I saw completely different. The fact that, the prosecutor can appeal an acquittal, and the fact that the defendant can testify without being sworn in or being cross-examined, and the whole area, which is still has not really come down, but is much of the trying to accommodate the emphasis of the civil law system on written. They are so much more lenient about taking written testimony, including witness statements. Right. And our hearsay rule in American law is certainly full of exceptions, but there's still a kind of a fundamental rule about, unless they fall into an exception, you have to have a live witness. And there was a constant struggle going on over there as to how far civil law, because it's so much, you can see the obstacles, the problems on live witnesses in these kinds of cases, especially in The Hague when the actual witnesses are out in other countries. You have to pull them in. We heard a lot about this in the last couple of days. You have to pull in the witnesses from other countries. You have to send escort services. Sometimes I lived in an apartment just above the fellow who was number 2 in the witness protection unit. And somebody had to get in his car and drive hundreds of miles, and pick up a witness and drive them back again. Then they had to be put up in a safe house in The Hague. And then there were problems. But the point was that everybody, the prosecutors certainly would prefer it if you could just have the statement there, and that was something I resisted, and some of the English judges, I know Judge May, Judge Hunt, and others were very skeptical about that, and there was a touch and go, give and take there. We didn't always win. I think it's gotten much more tended toward the civil side since I left. On there, so there were those kinds of things that one had to get used to. I had the sense, I said this out loud in an interview to the International Herald Tribune after I left, which probably didn't win me any friends remaining over there, that, I thought judges should not be put in charge of the trials unless they'd had some experience in the courtroom. Actually, the Rome statute now has that right in its statute. It says that there has to be a predominance of people with experience in the criminal justice process in the trial and pretrial. That's what I was talking about. It's all right in the appellate level. You can have the international scholars, but you're down there, and these people, it's their lives that were at stake, and the witnesses and everything else. You have somebody that doesn't understand the process or asks some kind of question that's going to get reversed. It's going to reverse the case on appeal. It's a very, it's not a desirable situation on there. But I thought it was a fascinating, process, fascinating couple of years, and I wouldn't have given up the experience for anything. On the Nuremberg thing, we did depend very heavily on, at that time. At that time, the court didn't have, our court did not have any precedent. It had the Tadic case, which was like the only case on record. So you had to go back to the Nuremberg precedent. And one of the cases, and Kelly Askin worked with me on this. She came over. I did not know her before then, but she had worked a year or two before I came over there for a while for one of the judges. And so we dug into the Nuremberg cases. We had a case of the prison guards, prison commandants, in one of the Omarska prison camps, which was the most notorious one, the one where they took the pictures which looked like German concentration camps. Yeah. So we had 4 of the commandants, the deputy head of the camp and 3 of the shift commanders on there, and it was under, the maltreatment of the prisoners, etc. So there we went back to all of the Nuremberg cases, some of them counsel number 10, but the prison camp cases on that, and relied, very heavily. It was a case called Kavachka, and if you look at that, you'll see it's almost entirely, relying on or depending on, etc., on those earlier Nuremberg cases. Yeah.
Interesting. This is an exploding. You were appointed to the Iraq Intelligence Commission. That must have been interesting.
It was, and it was a sort of one of those things that's dynamics. I had no particular, by this time I'm off of the court for a couple of years, but I'm a dyed-in-the-wool Democrat. Certainly had no Republican connections, but one of the other judges on the court, who were funny because we had, we were sort of at each other on substantive areas. He was a Reagan appointment, and quite a conservative judge, also quite sharp-tongued or sharp writer. So we spent the first couple of years after he came on the court sort of, majority or dissenting each other back all the time. Eventually, over the years, this often happens on courts. Everybody gets a little bit more moderate. You don't change your substantive, but you sort of learn to deal. You get more thick-skinned, etc. So in the end, we were sort of quite friendly. And the Iraq Commission was supposed to be, bipartisan. It was supposed to have an equal number of Democrats, Republicans. So he recommended me, and I had no idea. I was at a Justice Initiative meeting in New York, and I got called out of the meeting to take a phone call from Andy Card, and who was then the chief of staff in the White House, and he said, Judge Silverman really recommends you for this. He's going to be a co-chair, etc. I knew about the dispute only as what any other citizen would know. and he said he'd like to announce it this afternoon.
Oh my gosh.
This was never mind vetting, that after that you had to get all the stuff for. They announced it before. I had whatever clearance I had to get on the court, but these had to be super clearances, and so it was a very interesting experience. Basically, we came out with the fact that the intelligence people had not done their homework, on the national intelligence estimate at all. But a lot of it that was sort of half of the report. The other half of the report was the Intelligence Reform Act had been passed, but it hadn't been fleshed out, or recommendations on, how it should run. Many of which were adopted. I can't really tell you whether they've been successful or not. The intelligence community has been in such a turmoil for the last, 7, 8 years, and then this was before, just as we were finishing the report, the Abu Ghraib stuff was just beginning to come out, so it was hard to tell. But it was a very interesting experience. The president of Yale was on the commission, the retiring president of MIT, an admiral. I was the only woman on the commission. Senator Robb, or former Senator Robb, and another person who had come out of the Clinton Defense Department, Walt Slocum. Anyway, it was an interesting year, and I learned a lot about the intelligence community, which has made me, if anything, more skeptical of how, how the whole relationship between policymakers and the intelligence community, which are supposed to, I won't say fact finders, because a lot of it is analysis of existing information, or even of the information they get from covert actions, but the dangers of policymakers using them. They're part of the executive, but using them, or tilting them, or whatever you want to say, I think is a real danger. On the other hand, I'm very much thinking that executives have to keep them under their control, because I would not like to see these people just. I think the whole problem with the intelligence community is it's part and parcel of certain parts that I'm not talking about just the analysts of, open information or something, but the people who have to deal with covert operations and secret information. They're taught to lie. No, it's part of their job, I understand that, but that gets to be something. So I think the thing that bothered me most about it was I felt, in some cases, in light of information that came out subsequently, that they lied to us as well, which is a little bit scary.
As you reflect back on your incredible career, are there a couple of highlights, things that you'd say, I made a difference? Or
Well, I suppose so. Actually, one of the ways, in terms of cases, one of the cases that I did before I went into the government at all, during my public interest phase, I'm really proud of, though, like everything else, important things, it's rare that they come out perfectly, but we brought only the second case in the country to get special education for mentally ill, mentally challenged, I guess is the right word, mentally retarded, but anyway, children who at that point had no rights, and it was just up to the Board of Education to decide if they had money enough to have special classes, and some of them had never been to school, and we brought a class action which resulted in a decree in D.C. which said that every child, had a right to an education which would be sufficient to his or her needs. Now I know that thing, that particular formula, but that was the formula we were able to adopt. It still remains to be completely implemented, but there has been a cosmic change between nothing and having a whole program of special education which will go back and forth fighting, are they spending enough on this, are they doing too much in private tuition versus public classes, but still it's a wide enough program to encompass the right of all children to be. Now that, our case and one other case in Pennsylvania became the foundation. We then went to Congress, testified about that, and that was the very beginning of the Education for Handicapped Children Act, later become the IDEA, the individual, I forgot what the initials stand for, Individual Development Education Act, but that became the foundation for the whole program now. So I felt that was something where you did make a difference. Before I went in, I suppose whatever role, it was just, one of many, played in the Foreign Intelligence Surveillance Act while I was in the Justice Department. The 20 years I spent on the D.C. Circuit were probably the happiest career-wise of my life, because while I was on it, I wrote over 800 opinions. A couple of them dealt with free speech and the right to demonstrate in favor of peaceful demonstrations in front of embassies in Washington. One of them was during the period when people were demonstrating in front of the Russian embassy because of Soviet jewelry and stuff. The D.C. ordinance said you couldn't even peacefully demonstrate anywhere near. It wasn't just the 50, it wasn't a question of egress or impeding access to. It was just you couldn't be anywhere in the vicinity. It's an interesting case. I dissented. I was on the panel with Bob Bork, and very funny. It shows you what experience can do. Wonderful person I knew who was a judge visiting from the Federal Circuit, Oscar Davis, who had been in the solicitor's office in the New Deal, probably in the Jackson era, and known as a liberal, and I could not figure out why he came down on that side of the case. And once, much later, I asked him afterwards, and he said that he remembered when he was in Washington, he was older than I was, the pre-war Nazi period when Nazis were demonstrating in front of various offices in Washington, and it so affected him that he didn't like to see this. But we went up to the Supreme Court on my dissent, and the Supreme Court upheld my dissent over Bob Bork's opinion. That was just one. The other one that's interesting, a little bit more relevant to this, was one of the Americans who had been in Nazi Germany, and even though he's an American citizen, he'd been picked up, and he was taken to one of the camps along, I think, with maybe some other members of his family. But then he was dispatched to the I.G. Farben Company under sort of forced labor. And for many years, eventually, after the liberation, he came back and he sued the German government. He did not come under whatever program they had, I don't know, and minors, limited program for reparations. But he sued and they, of course, raised the Foreign Sovereign Immunities Act. And the question whether or not the kind of basic slave labor that he was subjected to should be an implied exception to the immunity of the government because it came under jus cogens, as a kind of basic. So my colleagues, the district court judge, who you may have heard of, Stan Sporkin.
Right.
Yep, okay. Stan is a good friend, lovely guy, etc. He wasn't always a dot the I, cross the T. So he thought the guy should get reparations, but he either didn't have the time or whatever the inclination to do a great studious opinion on it. So when it came up to the Court of Appeals, I had two very conservative colleagues, and they, gave it the back of their hand, as it were. But I thought it deserved more consideration than that. So my law clerk and I, did, and she did a lot of the spade work. And we worked on it. We wrote a very long dissent on, you know, whether or not there should be or is implied or, you know, an exception for, you know, in this case, yeah, it would, for the most basic kind of crimes against humanity, et cetera, for this. And that was just a dissent. The Supreme Court did not take cert, but here's what happened in the process. The German government, because while this was going on, apparently they were holding fast to defending it, saying no, they had no. But the successor to I.G. Farben, or whoever was running that, didn't like the publicity associated with this guy who'd been under slave labor for so many years and couldn't get any reparation. So they came to back to Stan Sporkins, because by this time it was remanded for judgment, you know, formal judgment. Yeah. They came to him and said, we'd like to do a settlement kind of thing. And so what they worked out, I mean, the case didn't get revived, but they worked out what became a Justice Department implemented or Justice Department administered fund for these people, for American citizens who had been taken and working in there. And so Stan Sporkin, you know, called me up one day and said, come on down to the district court. I'm going to, you know, put my stamp of approval on this settlement. And so, you know, it gave some people some reparation, obviously probably not as much as many other cases. And it came out of the suit. It wasn't a vindication legally of the suit, but it came out of the, you know, it came out as a result, yeah.
What's next?
Look, not too much. Look, not too much. Not too much by the law of averages. Not too much. Not too much.
But you're an amazingly energetic person.
Yeah. No. I work with some of the NGOs. I've you know, I've worked with the Justice Initiative. The one Kelly and I have been on their board. I also I co-chair the global pro bono projects for a law firm that a good friend of mine who died much too young had gotten through his law firm, which is a major law firm, and they started a program whereby they gave, apart from the regular pro bono, which they continued, a program set up whereby their partners and younger people on a selected basis, but still can take up to 2 years to do nothing but pro bono in these global projects abroad without any, they don't have to keep up their regular. And so they've undertaken, you know, a series of interesting programs abroad. I co-chair the advisory committee that helps select the projects, evaluate them, raises questions that are going on. So there's lots to do, lots to do.
Well, we're delighted that you found something to do here in Chautauqua.
Well, I am too. I wouldn't have missed it for the world because I know a lot about Chautauqua. I mean, it's history, obviously, and we're going way back to the suffragettes, etc. But I never had an opportunity, and it's such a unique place. I mean, visually, aesthetically, all the intellectual ferment that's going on. So it was a lucky phone call that Dave made to me, and lucky that he didn't tell me earlier that I had to make a speech, or I might well have said, gee, that's the end of the summer, you know, I'm not sure I want to do that. But I'm very glad I came. It was a pleasure to meet you and your family, and lovely boat ride to finish it out.
Well, we're delighted you're here, and we hope this isn't the last time you'll be here.
Oh, me too. Me too.